This case is set on the court's docket for a second permanency and final. The department is present through Ms. West. Katie Casper is the children's attorney and guardian ad litem. Mr. Kinslow had been conditionally appointed for the alleged father, Mr. Brandon. He was unable to locate him and was discharged. The department has served Mr. Brandon, correct?
Yes, Your Honor.
Mr. John McLeod was previously conditionally appointed for the alleged father, Mr. Curran Foreman. Mr. Foreman requested genetic testing at the adversary. The court ordered the genetic testing, and Mr. McLeod was discharged for that alleged father. Mr. Dennis is present with the mother, Ms. Ricketts. You may call your first witness.
The department calls Kelsey Rudd. Ms. Rudd, do you have any updates on the children since the amended court report was filed?
No, not at this time.
Does the department have any concerns about the care that the kids are receiving?
No, ma'am.
And am I correct, ma'am, that these kids are in placements that have indicated they are willing to take care of them long term?
Yes.
I say placements, but they're actually together in one placement, correct?
Correct.
So, ma'am, do you have any other updates as it relates to the children?
No, ma'am.
And as it relates to the mother, I think your court report mentions that she has moved to Pennsylvania within the last couple of months, correct?
Correct.
Do you have any update on any progress she's made on her services since she's moved to Pennsylvania?
Not at this time.
So, ma'am, has she had any contact with the children since she has moved?
Yes, she's had video calls.
And about how many video calls has she had?
I don't have an exact number off the top of my head. A couple.
And how long, if you know, do these video calls last?
About 40 minutes, because that's the limit on Zoom for the free version.
Okay. And have there been any issues reported with those video calls that she's had with the children?
No, ma'am.
Do you have any other updates as it relates to the mother and her progress on her family plan of service?
Not at this time.
And as it relates to the fathers, do you have any updates on them?
No.
And have you had any contact with Mr. Brandon?
I have not. The last time I had contact with him, I believe, was in April. He had come to the CPS office asking about a visit, but I wasn't there at the time, and I let him know that he would need to go drug test in order to have a visit. He did not go or answer any of my calls after that.
And what about Mr. Foreman? Have you had any contact with him?
No, ma'am.
Am I correct, ma'am? Then he is not submitted to genetic testing at this point.
That's correct.
Do you have any other updates as it relates to this case?
No.
Is there anything else you feel the court needs to be made aware of?
No, ma'am.
I'll pass the witness.
Mr. Dennis?
I have no questions, Your Honor.
Casper?
Ms. Rudd, despite having moved several times, these children have been in this placement for approximately 5 months. Is that correct?
Yes, ma'am.
And they are doing remarkably well. Would you agree?
Yes, ma'am.
They're very bonded to the current caregivers.
Correct.
They're doing well in daycare and school.
Yes.
Okay. Do you think mediation might be helpful in this case?
I don't see how it would hurt anything.
Okay. I'll pass the witness.
And Ms. Rudd, I'm not sure if you've been the caseworker the whole time. It looks like Ms. Ryan, on behalf of Mr. Foreman, requested genetic testing November 15th, 2022, and the court ordered genetic testing on that day. I'm sorry. Yes, it was ordered at the adversary. Then we discussed it again on 3/14 that he wanted genetic testing. There was testimony at that time he had not done the genetic test yet, that the OAG was trying to set it up. You are still under oath, but can you tell me if in fact it's been set up for him? How many times has it been set up? And I mean, has it been a miscommunication, or has he failed and refused to go do the test that he's requested?
We haven't been able to get contact with him. I've sent letters to the address that was on the genetic testing order. I did a diligent search and sent letters to the addresses that came up on there. I've called the phone numbers on there. I've called 2 different phone numbers trying to get in touch with his mother. I I at this point, I kind of believe that he just doesn't want to be in communication with the department. But yeah.
You haven't received any calls from him saying, how do I get that DNA test set up that I asked for?
No, ma'am, not at all.
All right. And by now it's been many, many, many months. Any reason, Ms. West and Ms. Casper, I wouldn't go ahead and make a finding today that Mr. Foreman is the father of Autumn based on his refusal or failure to submit to the testing that he's requested?
No, Your Honor.
Yeah.
All right. The court will make those findings. The court will find that he's the father. He requested genetic testing. He has refused to cooperate with the department. He has not submitted to the testing. I'm finding that he's the father. I'm establishing the parent and child relationship between him and the child for all purposes. The court further has reviewed the progress of the parents on the family service plan. I will continue the department as the temporary managing conservator. The court finds that the department has made reasonable efforts to finalize and to reunify, but also to make and finalize an alternate plan. The court approves of the department's plan. The court finds that the parents are not making progress on their family service plans. Ma'am, the law does require that I admonish you that if you are unable or unwilling to provide a safe environment for your children, your parental rights could be subject to restriction or termination.
Ms. Harris, do you have any updates on how the children are doing since the court report was filed?
Next hearing
No, ma'am.
The kids are doing well in their current placement.
Yes, they're doing great.
Does the department have any concerns about the care that they're receiving?
We have no concerns.
And ma'am, the goal is now relative adoption, correct?
That's correct.
Are the caregivers willing and able to take care of these children long term?
Yes, she is.
And as it relates to the mother, do you have any updates on her progress in her family plan of service?
There is no progress for Ms. Monahan.
And am I correct, ma'am, that she is not drug tested since April?
That's correct.
And when she was drug testing for the department, she was testing positive at extremely high levels for methamphetamines, correct?
Correct.
And obviously, I'm guessing that is a concern for the department.
Yes, it is.
Is the department wanting the mother to engage in any sort of drug treatment program to address these really high drug tests?
I think it would be in her best interest to complete inpatient rehab with the levels that were given in April and before.
And has the department identified any inpatient treatment programs that the mother can participate in?
There are several inpatient facilities that were contacted by myself, not necessarily just for this case, but for all of my cases. And I've been able to locate several rehab facilities.
So at this point, the department believes it would be best for the mother to engage in some sort of inpatient treatment program, correct?
Correct.
Are there any additional services the department believes need to be added to the mother's family plan of service?
No, ma'am.
And ma'am, since the mother has not drug tested since April, has she had any sort of contact with the children since April?
She has not seen her children since April 5th.
Do you have any other updates as it relates to the mother and her progress on her family plan of service?
No, I've attempted contact with Ms. Monahan at a minimum of once a month, and I have not been able to see her, or she's not responding to any of my messages or phone calls. And she says she's not getting them, but I've spoken to people at her residence who just said that she wasn't there, or she just left, or she hadn't returned back. So I'm not sure how to contact her.
Okay. Do you have any other updates as it relates to the mother?
No.
And as it relates to the father in this case, am I correct that he is currently incarcerated?
That's correct.
Do you have any updates on as it relates to him?
Mr. Hayes has sent a chapter or two from a parenting packet provided by the department at a minimum of once a month. And I just asked him to provide his feedback on what he has learned from the packet that I sent him. But besides that, there is no other services completed by Mr. Hayes.
Do you have any other updates as it relates to Mr. Hayes?
No.
Is there anything else you feel the court needs to be made aware of?
Not at this time.
We'll pass the witness.
Mr. McLeod.
In terms of Ms. Monahan, I know at the beginning of the case, she had been involved in a pretty serious motor vehicle accident, was injured, including a head injury. Do you know how she recovered from those issues?
I'm not sure.
Okay. In terms of the referrals on her service plan, I know that she hasn't, she didn't do the OSAR, didn't complete the psychological, that type of things. Are those referrals still active?
I think they will expire at the end of July.
Okay. In terms of the outpatient treatment program that you're asking the court to order Ms. Monahan to do.
Inpatient.
Excuse me. Yes, ma'am. I'm sorry. Inpatient. The inpatient program that you're asking the court to order. Do you know what the duration of that program is?
It just depends on the client and their willingness to participate, but they can be anywhere between 30 to 90 days.
Okay. Has Ms. Monahan given you any specific reasons as to why she's not started or completed these services?
Ms. Murnahan stated that she doesn't have a vehicle because the vehicle that was hers was the vehicle that was involved in a motor vehicle accident in January. But I have actually confirmed by several people that the car is actually working and running. Sometimes it's at the house when I go by, sometimes it isn't. And I've, like I said, been able to confirm that the car does work. So the lack of transportation is the reason that she gives, but it's not valid.
Okay. I've seen, and I can't remember where, it may have been in your report and I just can't remember, or whether it was someplace else, that she has given some reason for not doing things is because her mother, I believe, is ill and she's having to take care of her mother. Is that something you're aware of?
Ms. Murnahan did voice that she is the caregiver for her mother, but as I stated, I've gone to the house unannounced several times, and each time that I've been there, she was not there. So her having to take care of her mom, again, it's not really a valid reason because she's not there.
Does her mom live in the same home?
Yes.
Okay. Pass the witness.
Mr. Kinslow?
Yes, thank you. The report says relative adoption. What is the relationship to the possible adoptive?
It is the mom's stepsister.
My client has turned in a caregiver resource form. Has any action been done looking into his caregivers that he suggested?
Not at this time, due to that caregiver that he suggested being placed in Ohio, and we have a local relative here in the state of Texas that's not too far from the parents.
And what is the concurrent plan?
Family reunification.
I'll pass the witness.
Ms. Hummel?
Ms. Harris, you and I have had some discussion about obtaining some additional medical records from the girl's birth to potentially help medical providers treating Riley, correct?
Correct.
She's found to be very, very small for her age, and basically they want to be able to have as much information as possible as they're testing and doing what they can to treat her, correct?
Correct.
And you said you're going to work on that to get those records.
Yes, the records that I got, I read through them. They didn't really say give an exact gestational age or their drugs, if there was any in their meconium at birth, but I will request additional records to see if I can obtain that information.
Okay. And the current caregiver certainly seems willing and able to provide long-term care for the girls?
Correct.
All right. I'll pass the witness.
Anything further of this witness?
No, Your Honor.
Any further witnesses?
No further witnesses.
Mr. McLeod?
No witness, Judge.
Mr. Kinslow?
I have no witnesses. I would make a request that we determine if there needs to be some form of mediation, maybe earlier in this case than typical.
Okay, would y'all like to go to mediation before the next hearing on November 7th?
Judge, I wouldn't, just on the hope that Ms. Murnahan might could get her ducks in a row. She has had a previous case where she did successfully complete, so I don't want to rush it. Plus, she's also got some other issues that might be impairing her ability to, or her progress on the plan. But I'd like to give her as much chance as possible.
All right. The court has reviewed the progress of the parents on the family service plan. Continue the department as the temporary managing conservator. The court finds that the department is making reasonable efforts to reunify and also to make and finalize an alternate plan. The court approves of the department's plan. The court finds that the parents are not making progress on their family service plans. I am adding that the mother will submit to and successfully complete an inpatient treatment program for substance abuse. I am further suspending mother's visits unless and until she successfully completes that drug treatment. There are no parents here to warn for a second permanency and final. The department is present through Ms. West. Spring Thummel is the attorney and guardian ad litem for the child. John McLeod is present for the mother. Mackenzie Nunn. Seneca Minute has been found by genetic testing to be the father of this child. An order was signed by the court on 6/19/2023. Mr. Minute has been served and is in default. Is that correct?
That's correct, Your Honor.
Are you asking to dismiss your unknown father allegation?
Yes, Your Honor.
All right. We'll take up second permanency. You may call your first witness.
The department calls Siobhan. Ms. May, do you have any updates on Kylan since the court report was filed?
Yes, ma'am, I do. Since the filing of the court report, Kylan did have an appointment with Hope and Believe Therapy. He will have occupational, physical, and speech therapy services 3 times per week. Starting this week, he will have those sessions. They'll be 1 hour each, and his caregiver, of course, will take him to those services.
And, ma'am, am I correct that the goal right now is conservatorship?
Yes, that is correct.
And the placement is already licensed, correct?
Yes, ma'am, that is correct.
And so will those therapeutic services be able to continue once the department is dismissed?
Yes, ma'am, I believe so.
Do you have any other updates as it relates to Kylan?
I do not.
And as it relates to the mother, am I correct in that she is incarcerated?
Yes, ma'am, she is.
Have you had any contact with her since she's been incarcerated?
Not since she's transferred to the facility in Gatesville. Prior to that, I met with her monthly when she was at Highway 6.
Do you have any updates on her since the court report was filed?
No, ma'am, not anything other than her being in Gatesville.
And am I correct in that Mr. Seneca Minute was found to be the father of Kylan?
Yes, ma'am, that is correct.
And have you had any communications with him?
Yes, ma'am. I've been meeting with Mr. Minute at Highway 6 jail as well. I did meet with him and confirm with him that he was the father of Kylan. And the department did provide him with a court report and any other documents to request an attorney or provide a caregiver resource for him.
And has he returned any of those documents to the department?
No, ma'am, not at this time.
Am I correct that he indicated he didn't want to work services in this case?
He did indicate that he didn't want to work services based on his history with the department. I did advise him that we do have a provider that could go to the jail to provide him with any services should he change his mind and decide to engage. And I believe Dr. Schindler has met with him maybe once.
Okay. And am I correct, ma'am, the department set up services for him and filed a family plan of service?
Yes, ma'am, that is correct.
Well, is there anything else the department is asking for Mr. Minute to do while he's incarcerated beyond what's already listed?
No, ma'am, not at this time.
Do you have anything else you feel the court needs to be made aware of at this time?
No, ma'am, not at this time.
We'll pass the witness.
Mr. McLeod?
The court ordered the plan for Mr. Minute?
Yes, sir, I believe so.
Okay. I want to make sure that I understood what you said in terms of Ms. Nunn. You do know she is already in Gatesville, correct?
Yes, sir, I do know that.
Okay, I was a little unclear on that. She's there, as I understand the report, to participate in some sort of drug treatment program. Is that correct?
Yes, sir. It's Safe P. It's a 9-month program.
Okay, that was, well, okay, it's 6 months. It's going to be 6 months there, 3 months in a halfway house. So maybe in the halfway house, she could continue to work some services possibly. That was my question, if you knew which program she was in and how long the duration would be.
Yes, sir.
I know your report indicates that she really is in support of the conservatorship to the current caregiver. When was the last time you spoke to Ms. Nunn regarding that?
I would have spoken to her in June.
Okay.
It would have been in June when I went and saw her and spoke with her about her going to Gatesville, the permanency goal, visitation, all of those things on the case.
Okay. And I know that the report indicates she wanted to be named a possessory conservator. Did you talk with her about any type of visitation schedule? I know you talked about that being, your report indicates being supervised. Has she made any type of request for frequency?
She has not. I don't recall if I gave her the specifics. I know the caregiver was speaking about what she would be willing to do. I don't recall, Mr. McLeod, if I gave her those specifics or I advised her that we had been in contact or trying to reach out to you and you would let her know.
Okay. What did the caregiver, what was she willing to give?
The caregiver is willing to offer 2 visits per month, supervised up to 4 hours. Granted that mom drug tests and is negative, but she is willing to increase those visits. But that is what she is offering at this time.
This sounds a whole lot like settlement negotiations. I'm not sure this is the time nor the place
And I was just trying to find out kind of what the caregiver had mentioned, Judge. That's all the questions I have.
Ms. Thummel.
Ms. May, have you confirmed if the caregiver could still receive the PCA benefits?
Yes, ma'am. And I'll be providing her with the PCA documents so that we can get those taken care of. I have a meeting with her in Kylan this afternoon.
Great. And then the court report lists mom's drug testing. The last requested test listed was January 26th. And then she was incarcerated April 7th, 2023. Were there any tests between February and April?
No, ma'am, she did not engage in drug testing. I did offer her an opportunity to test prior to going into jail so that she could at least have a virtual visit with her son. Even though she did not test, I still offered her the opportunity to have a visit with him, and she did not do that.
Okay. And then did she start her therapy before she went to jail on the April 7th?
No, ma'am. Okay.
Do you know if she completed the appointment with her psychiatrist and MHMR on February 20th?
No, ma'am. I'm sorry. No, ma'am.
Okay.
Did you ever that a no, ma'am, you don't know, or no, yes, you do know, and no, she did not?
I don't know that she completed it. Thank you, Your Honor.
And then did you ever receive the comprehensive psychological evaluation that was provided through the probation department?
No, ma'am, I did not receive that.
Okay. Do you know if she participated in the protective parenting classes between February 2023 and April 7th, 2023?
My last update with Dr. Shinder, no, ma'am, she did not.
Okay. I'll pass the witness.
Anything further of this witness?
Just briefly, Your Honor. Ms. May, am I correct as it relates to Mr. Minnett's family plan the department compiled? It was actually filed on June 15th, 2023?
Yes, ma'am.
Okay, and so we've actually not had that family plan of service court ordered. Is that correct?
That is correct. I do apologize. It was recently filed in June, but no, ma'am, it has not been court ordered. Thank you.
But the department did provide Mr. Minette with the family plan of service and information as it relates to Dr. Shinder coming over to the jail.
Yes, ma'am, we did provide that to him at our face-to-face visit.
And so, ma'am, is the department asking for the court to order the family plan of service as it relates to Mr. Minette?
Yes, ma'am.
I have nothing further, Your Honor.
First, I will dismiss the unknown father as we have a father. The court has reviewed the progress of the parents on the family, actually of the mother on her family service plan. I will continue the department as the temporary managing conservator. The court finds that the department has made reasonable efforts to reunify and also to make and finalize an alternate plan. And the plan is conservatorship to the current caregiver. Is the concurrent goal relative adoption or fictive kin adoption or family reunification?
I think the concurrent plan is still adoption, Judge.
Okay.
If we're going to do conservatorship to the caregiver, I would like her to have the PCA benefits.
Okay. And did I hear that she's already licensed?
Yes.
Okay. All right. Perfect. And she's aware of her options and her preference. I mean, her choices, the current caregiver.
My understanding
yes.
is.
I'm sorry. Yes.
Okay. All right. The court approves of the department's plan. I will make the family service plan for the father in order of the court. The court finds at this time the parents are not making sufficient progress on their family service plans. There are no parents here to warn. I'm setting this for a final hearing on the department is present through Ms. Gongora. Robin Houston is the attorney and guardian ad litem. Sam Kinslow is present for the mother, Tristan Bayer. Mr. Martinez is present with the father, Jesse Davis.
I did request Ms. Bayer be brought from the county jail.
You did?
Yes, I saw Marcus made the request. He copied it to me.
I don't have anybody from the jail here. This is a status hearing. Is your client, does she have any problem with what's on the family service plan?
She really doesn't. I did talk to her since then to confirm that, but she hasn't signed it, but she does not have any issues with what's on the plan.
Thank you. You may call your first witness.
The department calls Terica Taylor. Miss Taylor, did you hold a PC in this matter?
Yes.
Okay. Were both parents in attendance, or were you able to go over the family plans of service with each of the parents in this case?
Mr. Davis did attend the PC. I did review the family plan of service with Miss Bayer, and she did sign the family plan on June the 27th at McLennan County Jail.
And that is the signed copy is not the one that is currently on file with the court, but it is the same one that was created. Is that correct?
That is correct.
Did Mr. Davis go over that plan and sign it?
He did attend the PC. We reviewed the plan on 6/12. However, he did not sign it. I was unaware that he was out of jail at the time I visited him at his residence.
Did either of the parents indicate any issues with the family plan of service at the time of you reviewing that plan with them?
No, ma'am.
Are there any issues that have been brought to your attention regarding services?
No, ma'am. I will say yes, Mr. Davis. I have requested a worker for Mr. Davis. I have emailed Region 3 quite a bit, trying to get a hold of the supervisor. He is aware of his services. He has been in communication with me every time his color is announced. However, a facility has not been identified for him to drug test that. And it's not his fault that services have not been coordinated, but he is aware of the services he has to complete.
And you're working with that other unit because he is not currently located here in McLennan County.
Correct. He resides in Dallas, Texas.
And I believe you already stated it, but you're already making it very clear that you as the worker on this case understand that his lack of drug testing so far is not on his, on anything on Mr. Davis. He is doing exactly what he is being asked of by the department. And it's just, you need a little bit more time to help coordinate those efforts in Dallas.
Yes, ma'am. He is texting me every day. He's very engaged and ready to do what he needs for his child to return home.
And it's also accurate that this child is currently with paternal grandparents. Is that right?
Yes, ma'am.
Okay. Your Honor, I would just ask the court to take judicial notice of the family plans of service for both the mother and the father that are currently on file.
The court will.
I'll pass the witness.
I have no questions. My client has told me she approved the plan. I'll pass the witness.
Mr. Martinez.
Ms. Taylor, what type of visits is Mr. Davis having?
He has the standard visitation. However, he has not visited due to the services. However, I met with his grandmother yesterday. She does supervise visits, and due to the services have not been coordinated, not Mr. Davis's fault, I did assure her that it was okay for him to visit because he is texting and calling me every time his color is listed or called.
So he wasn't being able to visit, I guess, because the services hadn't started. He wasn't able to drug test, that type of thing. So he wasn't able to visit, but now he is going to be able to visit.
Yes, sir.
Okay. Because he has been staying in contact, and now he can go over there and see the child between 8 and 8 or something of that nature, while grandmother supervising.
Yes.
I'll pass with this.
Ms. Taylor, are you aware that Dad was on random testing, not the color?
Yes, ma'am. I asked him to drug test. We discussed the color code, but I was not aware until recently, and I requested to him to drug test.
So what I hear is he hasn't been able to have any visits because he hasn't been testing, but he wasn't on the color.
Correct. So that was when he first was incarcerated, is when that plan was made. I recently found out he was released from jail on 6/12, and that's when we discussed it. I did notify the caregiver of the drug testing, and then I recently went back over it with Miss Smith because she wasn't aware.
And there's the problem. He is not ordered to be on the color.
Correct. Correct. He was on random. The issue is that I'm unable to submit the paperwork for the A&D testing for him to test randomly, is what I've been testifying to. He is on random. I've been reaching out to Region 3 because I'm Region 7. I have no location to send the drug testing form for him. That's why I've allowed him to visit, because it's not Mr. Davis's fault.
Okay. I'm sorry. I thought you said he hasn't been able to visit.
No, ma'am. It's my fault. Well, the department's fault in Dallas.
Okay. And so I'm curious whether Mr. Davis needs to be on the color or random, because I was told at the adversary hearing that the department was requesting for random testing, and the family service plan that's been presented to the court says color code.
Correct. So I started reaching out to investigation, and that's when I identified that he should not be on color and it should be random.
Okay. So
but the issue was just getting his paperwork submitted.
So the family service plan needs to be changed as it relates to Mr. Davis.
Correct.
Okay. Ms. Houston.
Your Honor, I just have a brief follow-up question about the visits. Ms. Taylor, has he been able to visit at all since he has been out? Okay, but the visits are going to resume soon, and he is ordered 8 to 8, supervised by caregiver, correct?
Yes, ma'am. I reported that to Ms. Smith because she follows CPS policy to the T, and I had not made contact with her because I had a scheduled visit on the 10th, but she is aware that he can visit supervised by her at her residence, and those could have started yesterday.
Okay, great. Thank you so much. Pass the witness.
Anything further of this witness?
No, Your Honor.
The court will continue the department as the temporary managing conservator. I will approve the child's current placement and prior orders for visitation. I am making the family service plan for each of the parents in order of the court. However, I am modifying the family service plan that is on file as it relates to Mr. Davis. He is not on the color. Mr. Davis, you do not have to call that number every morning to see if it's your turn to test. You are on random testing. That means if the caseworker reaches out to you and asks that you submit to a test, you will submit to the test. Do you understand that?
Yes, ma'am.
All right. And you understand I have made the items in your family service plan an order of the court. You're ordered to do them. Your progress on your family service plan will be reviewed by the court at every future hearing. The law also requires that I let you know if you are unable or unwilling to provide a safe environment for your child, your parental rights could be subject to restriction or termination.
Yes, ma'am.
The next hearing is the initial permanency, November 7th. Second permanency and final is March 5th, 2024. Docket and May 13th is our second permanency and final. The department is present through Ms. West. 2 of the children, the subject of the suit, are present. At least I can see one of them. Are both of you there?
No, Mika didn't want to be in it.
Okay, thank you.
You're welcome.
Casa is the guardian ad litem. Casa is present through Ms. Chisnell and also Ms. Cooper. Charles Levy is the children's attorney. Mr. Howell is present with the father, Robert Adair. Sam Martinez is present for the mother, Eva Denny. Mr. Dennis is present for the father, Leonard Newman. And is it still correct that Ms. Denny and Mr. Newman are currently incarcerated?
Mr. Newman is.
For some reason,
Not aware about Miss Denny, Your Honor. To tell you the truth.
She's not in the lobby, and neither is Ms. Earl, Ms. West.
She texted me saying she's having technical difficulties. Your Honor, I can try calling her on my phone if that would expedite things, or see if her supervisor is available to testify.
All right, ma'am, you are under oath. Ms. West, you may proceed.
Ms. Earl, I want to talk about these children in turn. First, let's talk about Rainey. Do you have any updates on her since the court report was filed?
I do not have any updates for her. Rainey's doing pretty well since school's been out. She hasn't had any issues in placement or anything like that.
And what about Mika? Do you have any updates on her since the court report was filed?
No updates on Mika either.
And how about Isabella?
No updates on Isabella.
Ma'am, am I correct in that the girls have been having some weekly in-person visits with each other?
Yes, they have weekly in-person visits.
And how are those visits going?
They go pretty well. Nobody's reported any issues. The caregivers have reported that sometimes they interact more than other times.
Okay, but there haven't been any concerns reported with their interactions, correct?
No, no concerns.
Ma'am, at this time, the court report lists the department's goal as unrelated conservatorship. Is that correct?
Yes.
Okay. Has the department identified anyone to be considered as possible placement for these children?
Outside of their current placements, no.
And ma'am, your court report mentions a maternal grandmother, Ms. Tanya Denny. Is that correct?
That's correct.
Okay. Has she been having contact with the girls?
Yes, she has had supervised visits twice a month. The visits have been supervised for, I believe, the last maybe 3 months.
And are these visits between her and her, both for her and her partner?
Yes.
Have there been any concerns reported with the visits between the girls and Miss Tanya Denny and her partner?
No.
And so, ma'am, am I correct in that the department is considering trying to extend the contact between the girls and Miss Tanya Denny?
Yes.
But of course, the department wants some boundaries and parameters put in place so that Miss Denny can make sure that she's effectively protecting the girls, correct?
Yes.
Okay. And ma'am, am I correct in that the department with this expanded visitation or increasing visitation is hoping to work towards Miss Denny ultimately potentially being placement for these girls?
Yes.
Okay. Do you have any other updates as it relates to the girls at this time?
As it relates to the girls, I do not.
And as it relates to the mother, am I correct, ma'am, that she has been arrested a couple of times within the last couple of months?
Yes. 3 total.
Do you know where the mother is currently residing?
I believe she currently resides still in Waco.
Have you had any recent contact with the mother?
I did have contact. She had told me that she was attempting to log into court, but I'm not sure if she was able to.
To your knowledge, ma'am, has the mother made any further progress on her family plan of service since the court report was filed?
No.
Do you have any other updates as it relates to the mother?
No.
And as it relates to Mr. Newman, do you have any updates as it relates to him?
Since the court report, I don't believe so.
And Mr. Adair, do you have any updates on his progress on his family plan of service?
Not since the court report.
And ma'am, in the court report, it mentions, as it relates to individual therapy, that the department was informed that due to Mr. Adair living out of state, a provider in this state is like a provider in his state is likely his best option. Is that correct?
That's correct.
And where did the department receive that information from?
From I guess what I would guess is the receptionist at Counseling Network, and it's due to licensing across state lines.
Okay. And so at this time, has the department located any sort of resources within Texas in which Mr. Adair could engage in individual therapy?
I have not.
And has Mr. Adair brought any resources to your attention that provide individual therapy for him?
He had informed me after the last hearing that he was going to attend a therapy session, but then I never got any further information about that.
And have you received any information about services Mr. Adair is working through the Indian Health Services?
I did not. He reported he was struggling to contact them. I made several attempts to contact them and was not able to reach anybody that could provide me any information either.
Okay. Do you have any other updates as it relates to Mr. Adair?
The only other update, the girls had requested contact to an extent with Mr. Adair. I had set up virtual visits for them with him. They attended one. There weren't concerns, but after that initial visit, they requested to visit with his daughter and his girlfriend, but they requested not to visit with him at this time.
Has there been any further contact between Mr. Adair's daughter and girlfriend and the girls?
I have not gotten that set up as to where we could do that independently of him.
Do you have any other updates at this time?
No.
Is there anything else you feel the court needs to be made aware of?
No.
I'll pass the witness.
Mr. Dennis.
I have no questions, Your Honor.
Mr. Howell.
No questions, Your Honor.
Mr. Martinez.
Mr. Earl, when was the last time you had contact with Mrs. Denny?
I went to see her while she was still incarcerated at the end of June. And then I provided her this morning with the link to the hearing, and she let me know she was trying to log in. And then I haven't heard anything else since.
Does she have a residence here in the Waco area?
Yes.
Have you been to that residence?
I have. I've not been inside.
Thank you. I'll pass witness.
Mr. Levy.
Thank you, Judge. Ms. Earl, in terms of Rainey specifically, you would agree that she is fairly well-spoken and very mature for her age?
Yes.
All right. You also understand that during the case, and disagree with me if you do, that she has reached out when she had certain needs or things were concerning to her. In other words, she can speak for herself pretty well, correct?
Very much so, yes.
All right. She has asked me to ask you if she could have a visit with her grandmother, Miss Denny, during the time that she's off for the summer, unsupervised for a couple, 3 days, 4 days. Can you tell me what risk there might be in doing that, given that she'll reach out if there's issues and we could put some boundaries on that?
The department is concerned with Mom Eva Denny having kind of unlimited access to the girls without her completing a drug test or doing any services or anything of that nature.
Maybe I misspoke. I meant the grandmother.
Yes. So for the grandmother, the concern is if she's going to let Mom have access to these children while they're in her care.
Well, but at the same time, and I appreciate that that's a concern, but that would also mean that you don't trust Rainey to follow rules. It would expose the judge to being significantly ticked off with Rainey, and the judge tends to like responsible kids. I mean, you're going to have this concern tomorrow, next week, next month, and 10 years from now, aren't you?
That's correct.
All right. So basically, we're never going to allow this child, who is going to be 15 in a couple of days. You told me she's well-spoken and mature. So she's never going to get to have even a visit with her grandmother. But you said you guys are working towards extending contact, setting boundaries, and working towards Miss Denny being a placement. I got to be honest, you say smart stuff and good stuff, but it just seems meaningless to me. Tell me what I'm missing.
Well, we sent out a proposal for an extended visit during the summer to the legal parties yesterday.
All right. And so
set out the parameters of that.
1 second. Only one person can speak at a time. Mr. Levy, ask your next question.
And I appreciate that. And I apologize. I've not seen that yet. I've just gotten back from 2 weeks away. But being specific, I mean, if this young lady says, I'm not going to have contact with my mother, I mean, she knows how to use a cell phone, right?
She does.
All right. And if you think the grandmother's in touch with the mother, no doubt the grandmother who sees this child regularly and talks regularly could tell her how to contact her mother, right?
Yes.
Do you think she's been doing that? You have any reason to think that's happening?
That was one of the reasons why the visits were supervised, was to determine the conversations that were being had.
Yeah, not my question. The bottom line is, this is a pretty creative kid. She's not chained to a desk at the house, is she?
No.
I mean, she can find how to get in touch with her grandmother. You think she's smart enough to do that?
Yes.
You think she might be able to do it like out and about town or borrowing somebody's phone? I mean, my question is, I get the concern. I really do. I have no doubt everybody here would have that concern, but you're not even going to give her a chance to be trusted is what you're telling me. Is that right?
Well, and as I said, that's why we worked on this proposal to extend that contact and allow her some time during the summer to have an extended visit with grandmother. And, assuming that this visit went well, looking at scheduling another one.
Well, you understand that after July 4th, the summer flies. I didn't ask Rainey when I spoke to her when school started, but I'm going to bet it's middle of August. So how are we going to pull this off before school starts?
Well, the initial visit proposal was to start this weekend and then to have another visit over the weekend of the 29th, which would be for Mika's birthday.
All right. And this visit would be unsupervised?
Yes.
Pass the witness.
Any further questions of this witness?
I have no further questions.
Your next witness.
I have no further witnesses.
No, if I could just make a one-sentence compliment comment.
Sure.
In talking to both Rainey and Mika, they said very nice things about Miss Chisnell, and I thought I would pass that along.
All right. Miss Chisnell and Miss Cooper. Okay, I have a couple of questions. Number one, on the report, it says current placement type undisclosed. I have no idea why the placement type would ever be undisclosed, because I am required by law to consider the placement. I realize sometimes their names may be undisclosed. I realize the address may be undisclosed, but why would the type of placement be undisclosed, especially, well, that's my question.
That was a mistake on my part. I apologize.
All right. second off, I thought that I read that at least at some point, the children were not only did not want to be considered to go to either of the paternal relatives, but also were not looking at being placed with the maternal grandmother. Is that a mistake, or did I read it wrong?
No, it was just the paternal relatives that they were not willing to consider.
Okay. But the children would like to go to maternal grandmother, but the department has concerns.
Yes.
All right. So CASA, what is your position? What I'm wondering is, I don't disagree that we potentially start a little smaller than 3 days at a time, but I also am wondering why it wouldn't be every weekend. We are in the summer, or at other random times, depending on what's going on. What is CASA's recommendation with regard to starting the visits with the maternal grandmother? How frequent and how long?
Hi. Sorry, I'm a little hoarse. I'm all up on the over, a few days visits with the grandma. I do think it would be good to maybe let the visit happen and we kind of assess it and make sure everything was good and it worked out well for everybody. And then if need be or wanted, then every weekend would be a good option.
All right. Have you had an opportunity to visit with the maternal grandmother?
Yes. I've visited with her several times.
Do you feel confident that she understands how to follow a court order and what would go wrong if she refused or failed to follow the court order?
I think if it's laid out to her and seriously explained clearly what the requirements are, that yes, she could understand.
And maternal grandmother lives where?
In Riesel, which is just like 10 miles outside of Waco.
Okay. It's not Waco.
Not Waco. Mm-mm.
Okay. Mr. Dennis, Mr. Howell, Mr. Martinez, do any of y'all want to weigh in on whether, and are we talking all three children starting visits? All right.
Just a visit, Your Honor. But...
All right. Any reason we wouldn't, based on CASA's recommendation and clearly the children's desires? I understand the department's concern. The department always has to be concerned. So y'all tell me, if we start on weekends, Friday to Sunday, this weekend, and there's no reason to do one weekend and then not have another, and then skip a weekend. There's no reason. So I'm going to order weekend visits, but they will stop. Visits will stop if my order is not complied with. And Rainey, I'm glad you're here because you're going to be part of making sure that my order is followed. Okay. I always want young folks that are involved in CPS care. It's not your fault. You shouldn't feel like you're being punished, but the department has a responsibility and the court has a responsibility to make sure you stay safe. And so I'm going to make some orders. And if either your grandmother or your mother or anyone else tries to bend the rule, break the rule, you need to say, this is not going to happen, because if we don't follow the rule, we don't get to come back next weekend. Okay. All right. Let's start with Ms. Earl. First of all, I'm guessing Ms. Denny, it cannot be within 100 yards.
Yes, one of the stipulations that we had suggested was no contact.
Remain 100 yards from the home. Or I'm guessing that grandma might take the kids somewhere. So I'm not going to require that the whole visit occur at grandma's home. So Ms. Denny will remain 100 yards from the home or wherever the children are. No contact. And that means phone or social media. So for right now, if you're on a weekend visit with your grandma, y'all won't be on FaceTime. Y'all won't be on Instagram, TikTok, Snapchat. And again, if any of that gets violated, then you run the risk that I may not trust grandma. Okay. All right. What else? Any other stipulations? department or CASA or Mr. Levy? If you can think of anything, Levy, to make sure that we have bright rules so we don't accidentally violate them. Go ahead, Ms. Earl.
The other thing that we had was that the children will have access to contact CASA, Mr. Levy, or myself at any point they request that.
Okay. And in fact, if it seems like one of the rules has been violated, we expect that mainly it's going to be Rainey. She's the oldest one. CASA, Mr. Levy, or department. All right. Go ahead. Okay, go, Mr. Levy. I'm going to mute her for right now so she doesn't.
All right. Just two things pretty straightforward: that CPS get a working phone number from grandma so that can be provided. I frankly don't anticipate calling, but so that if anybody felt like they needed to call, that they would have it, and that grandma understands there must be a working number so that she can't say my phone got stolen, my phone went dead, my whatever. But then also, Judge, all of the different specifics I think are great. But I do think that grandma, because she's not a lawyer, she's not a person that deals in this world other than through this case. I think you start out with no contact means no contact with mom, not in person, not on the computer, not by phone, not listening in, not in the next row at the store. And then you can go with all the specifics. That's a pretty easy rule to follow. If she shows up, you can't let her in the house. I mean, it's pretty straightforward stuff.
All right. Well, Rainey just heard you, and I'm assuming that when we hang up, you're going to also be able to talk to grandma and make sure that she understands. All right.
Yeah, I just need a good number.
And Judge Casa does have one request.
All right, go ahead.
When the youth are dropped off, whatever representative from the department, whether it's Miss Earl or an HST drops them off, we would ask that the grandmother allow them to come in and take photos of the house that then be distributed to those of us involved.
Must allow caseworker entry to the home and to take pictures. All right. Ms. Earl, I think you're back. Is there anything further? All right. All right. The court has reviewed the report that's on file, the progress of the parents on their family service plan. I will continue the department as the temporary managing conservator. The court finds that the department has made reasonable efforts to reunify and is also making efforts to finalize an alternate plan. The court approves of the department's plan. The court finds at this time the parents are not making progress on the family service plans. I am ordering that weekend visits will start this weekend. They'll be every weekend unless there is a violation of my order. If there's a violation, there's a violation of the order, then the visits will stop until I can make a further order. Ms. Denny is ordered to remain 100 yards from the home. The grandmother shall not let her, she can't come to the front yard. If she comes to the front yard, she needs to contact Ms. Earl, Mr. Levy, and CASA. There'll be no communication whatsoever of any sort between the children and the mother during the visits. There shall be a phone number if anyone needs to reach the grandmother, and the grandmother must allow the caseworker entry to her home to take pictures. Parents, the law requires that I admonish you if you are unable or unwilling to provide a safe environment for your children, your parental rights could be subject to restriction or termination. I'll set this for a final hearing. Are we doing this final hearing in person, or are we putting it on a Tuesday for now?
I think a Tuesday for now, Your Honor. We can kind of take it from there.
September 12th will be the final hearing.
Thank you.
All right. Don't make me regret it.
My birthday's this weekend. It's on Friday. So thank you.
You're welcome. All right.
That was virtual hearing, Judge. I apologize.
And final, the department is present through Ms. Gongora. Ms. Robin Houston is the attorney and guardian ad litem for the child. Mr. Howell is present. The next case on the court's docket is 2022. He was appointed to attempt to identify and locate the unknown father. Mr. Martinez is present with the mother, Lexi Coops. All right. Are we taking up second permanency and resetting the final? Present. The next case on the court's docket is 2022. I have muted y'all on purpose. Number one, because y'all aren't the witness on the stand at this time, but also because you've got the YouTube going and it is, we can hear it. You may call your first witness, Ms. Gongora.
Yes, Judge. The department is asking to take up the second permanency, and my worker is Ms. Bridgewater, who I don't see here yet.
Thank you. I was looking for the worker that authored the report.
Now, Ms. Bridgewater, the goal, according to the report, states that it's unrelated adoption. Is that correct?
That is correct.
However, the report also indicates that the mother has engaged in or has completed just about all of her services. Is that also correct?
That is correct.
So what specifically is the safety concern that the department has, or any concerns that the department has regarding returning Miles to his mother at this time?
The concerns that the department have consist of when Miss Kooks was granted unsupervised visitation with Miles, she had a relapse. And so we're concerned that it could be a trigger the more responsibility she has to do with Miles, the more stress she gets, then, she could return to using drugs.
And so right now it sounds like it's more of a concern of Miss Kooks being able to maintain that sobriety. Is that correct?
That is correct.
And so in the report, it indicates that mom has not tested positive again since February. Is that correct?
That is correct.
Okay. And is it also accurate that the department just recently started giving mom some unsupervised visits?
We are going to be starting those when Miles gets back from his vacation.
Okay. And when is that?
That will be the 23rd, I believe, that he comes back.
But the department is interested in, just wait for me to ask my question. The department is looking at starting and going back to some unsupervised visits once he returns and is able to continue those visits with his mother. Is that right?
Correct.
And is it also correct that depending on how those visits go, the department could be looking at changing its goal by the time we come back for the final hearing?
Correct.
Are there any additional services that the department has identified that Ms. Kooks needs to complete?
None at this time.
And Ms. Bridgewater, there was also some talk early on in the case about potentially looking at an uncle as a potential family placement rather than Miles remaining in foster care. Do you have an update for the court on how that is going or what happened?
That home study was denied.
And so the department's not looking at changing placements at this time?
No, ma'am.
Are there any other relative options that have been given to the department by the mother?
No, ma'am.
Is there anything that we have not gone over or that is not listed in the court report that you feel the court needs to be made aware of at this time?
No, ma'am.
I'll pass the witness.
Mr. Howell, do you have any questions of this witness at this time?
No, Your Honor.
Mr. Martinez?
Ms. Bridgewater, I didn't know anything about the home study being denied, but why was it denied?
I would have to look at it again. I'm not 100% sure.
Would you mind getting in touch with me and let me know why it was denied?
Yes, sir.
And then as far as mother, have you got confirmation whether or not she's working?
She is working, yes.
And is she giving you confirmation? She gets VA benefits too. Is she giving you documentation on that too?
I personally have not received documentation of pay stubs from anything at this point.
Have you been able to visit her home?
I have.
And is it appropriate?
It is.
And she's still been maintaining that residence, is that correct?
Correct.
Is there anything other than obviously continue to stay clean? Is there anything else she needs to do?
Continue to progress in engaging with Miles correctly and making sure that, because he has ECI therapy and OT therapy, that, she incorporates the things to help, stretch his muscles and stuff like that when she does visits.
Is she aware of those things? I mean, has she been given?
I have not given her anything. I don't know about the prior caseworker, but I will be giving her a list of things like that tomorrow.
I passed witness.
Ms. Houston?
Your Honor, briefly. Ms. Bridgewater, you talked a little bit about the home study. I don't think I've received a copy of it either. So if you do have a copy of it, I would love to get a copy, please.
Okay.
And my understanding, though, also is that Ms. Kukis was also not really interested in placement at that home. Is that correct?
That is correct.
And further, from looking at the relapse situation, Ms. Kukis had about 3 months of sobriety, then relapse, correct?
Correct.
And then we're looking at like a little bit longer this time around, but we're starting on supervised visits again, correct?
Correct.
Okay, I'll pass the witness.
Anything further of this witness?
Not from me, Judge.
Your next witness?
I have no further witnesses.
Mr. Howell?
No witnesses, Your Honor.
But Mr. Howell, you did indicate at the pretrial or the docket call early this morning that y'all were able to identify someone that could be the father of this child, and that is Jose Salazar. Is that correct?
That is correct, Your Honor. I supplied the information to get the DNA ordered today.
All right. And Mr. Salazar is requesting genetic testing to determine whether or not he's the father of this child.
Yes, Your Honor.
I am ordering that genetic testing. And Ms. Gongora, you have all the information you need. And so Ms. Bridgewater, that order will be filed today. Is Ms. Bridgewater a service contact on the e-file system?
I'm not sure, Judge, but if she's not, I can make sure that I forward that to her personally.
All right. Please, Ms. Bridgewater, we're getting pretty late in this case. If you can see that it gets to the OAG, at least by the close of business tomorrow, and then just confirm with Mr. Howell and Ms. Gongora that you've been able to do that, get that to the OAG. All right. So I'm ordering genetic testing. Mr. Martinez, did you have any witnesses?
No, Your Honor.
Ms. Houston?
No, Your Honor.
All right. Again, I've ordered the genetic testing between Jose Salazar and the child. The court has reviewed the progress of the mother on her family service plan. I will continue the department as the temporary managing conservator. I will approve the child's current placement. The court finds that the department is making reasonable efforts both to reunify and also to make and finalize an alternate plan. The court approves of the department's plan. The court finds that the mother is making some progress on her family service plan. Ma'am, the law requires that I let you know if you are unable or unwilling to provide a safe environment for your child, your parental rights could be subject to restriction or termination. Our dismissal date is 9/25/23. I will set this for a final hearing. Is y'all's preference to set it on a Tuesday?
I was at this point, a Tuesday's fine, Your Honor.
Virtual. Are you asking Ms. Gongora that it be set at the 1 o'clock hour?
Your Honor, I don't believe that we're asking for anything to be set at 1 o'clock at this time.
All right. Well, I will set this then on September 5th.
Now, Ms. Scythe, your report clearly states that the goal is relative conservatorship, and it's by all indication, it seems like this is what the children are wanting and what the caregiver is comfortable with moving forward. Is that correct?
Yes, ma'am.
And in fact, I think your report also states that Miss Christian is working on her licensing.
She is.
Now, as far as the parents' progress, it doesn't seem that either parent is working their services. Is that accurate?
Mr. Davis has participated with Dr. Schindler last week with physical therapy.
And you said that started last week?
Yes.
Okay, and so that's very recent engagement. Is that right?
Yes.
And there have been some issues regarding his visitation, specifically with Mr. Davis. Is that right?
Yes. I mean, because of the drug testing, inconsistent.
And then when he did go ahead and do his drug testing, I believe, was it Eugene that stated that he has no interest in visiting his father at this time?
Yes.
And is that something that the department is trying to finalize some long-term plans after this case is over?
Yes, ma'am.
Okay. Are there any concerns currently with the father at this time?
No, not that I know of.
Now, the mother in this case, who's only the mother as it relates to Amon, is that correct?
Yes, ma'am.
It doesn't seem like she's participating at all as far as services or even visiting. Is that correct?
Yes, ma'am.
Is she, Judge, I think we lost Mr. Martinez.
I bet he'll pop right back in.
Has she indicated a reason to the department as to why she's not engaging?
No, she has not.
Are there any concerns that the caregiver has brought to the department's attention that you feel the court needs to be made aware of?
No, not that I know of.
And does it just appear that this caregiver seems to be the one who's just putting these boys first and just trying to do what's in their best interest?
She is.
Is there anything else?
The boys have started therapy as of last week also with Pursuit of Happiness.
And will they eventually be adding a family therapy into the mix once the therapist deems that it's ready, specifically with their father?
Yes. I mean, Dr. Schinder did try to do family therapy, like stated in the court report, but Mr. Davis did not show up both times that they tried.
Thank you. I'll pass the witness.
Mr. Pouch.
No question, John.
Mr. Lee.
Thank you, Judge. Ma'am, I'll try to be quick. In regard to the children, unless I read the court report wrong, it seemed like they were a little bit overdue on a 6-month dental exam. If I'm reading that right, has that been set up?
Yes, that has been set up.
All right. And has it taken place yet?
I think they have it scheduled this month.
Okay. I appreciate that. And just very quickly for Mr. Davis, and I'm trying to be more factual, I sort of made a list from a service standpoint. The court report indicates he doesn't allow entry to his home.
I have not been in his home, but previous caseworker has.
All right. Would you be kind enough to, request entry? I'll ask him about that in a moment. And then take some pictures.
Yes, sir.
I understand he's missed some drug tests. And
yes.
In terms of a budget, it says he's discussed his finances, but that doesn't really help me very much unless I missed an email that sort of shows money coming in and money going out, and how he would get these kids to school and therapy and doctors and all of that. Would you be kind enough to see if you can get him to do a budget? I'm going to ask the court to order that as well.
Yes,
does that make sense? Thank you.
Yes,
and then what I got out of your court report is the kids showed up twice for family therapy, which means the placement got them there, but for whatever reason, Mr. Davis didn't show up, right?
Yes, sir.
All right. And then according to Dr. Schinder, what I read in the report is dad continues to blame others and not take ownership for the fact that CPS is involved. Has that been your understanding as well from dealing with that, or just not enough contact to know?
I have not had enough contact with him, but from the statements he's made, yes.
Okay. And I guess my comment is, and it's really rhetorical, if he doesn't think he did anything wrong, then how are any of these services going to be worthwhile?
Right.
I mean, am I missing something there?
No, sir.
That's all.
Mr. Martinez.
Yes, I'm sorry, John. I think I got kicked out. Something happened to my internet here at the office. I'm sorry. I missed some of that.
Back in.
As far as the visitation, is it true that Eugene has engaged with visitation when he's been someplace like at a park?
I don't know. I mean, I did a visit on the 22nd with them at McDonald's, and Eugene did not want to go.
Okay. Is it possible? Well, have you ever heard of Eugene Davis, the father, playing basketball with Eugene Jr.?
No, I have not.
Okay. Is that something that could be explored as far as a visit being offered, like at a park where they could play basketball?
Yes, sir.
Okay. And as far as you say, you missed a couple of visits with Dr. Schinder. Was that Dr. Schinder that set up the family service plan? I mean, the family counseling with the children.
Yes, he did. Dr. Schinder did set up those family counselings.
Okay, because I was under the impression at one point that wasn't going to be set up. It has been set up now.
Well, Dr. Schinder tried to do it 2 different times, and Eugene didn't show up.
Well, in the last review hearing, it was set up and stated that they set that up, but the children didn't want to go on, and you are waiting on a therapist's recommendation to start some type of therapy. Is that still not the case?
No, Dr. Schinder did set up a family therapy. He tried to, and the kids did show up, but Mr. Davis did not show up.
Okay, so there will be family therapy that's going to be set up, and we can get Mr. Davis involved with that.
Yes.
Okay. And do you know when the next family therapy would be?
I do not know. We have to wait for the service provider to give us recommendations.
Okay. But he has been going to individual therapy with Dr. Schinder. Is that correct?
Yes.
Okay. All right. I'll pass the witness.
Anything further of this witness, Ms. Gongora?
Not from me, Judge.
Mr. Howell? Mr. Levy?
Thanks, Judge. Ma'am, just quickly, I mean, I appreciate Mr. Martinez's questions, but would you agree that if the kids show up for yet another family therapy session and dad doesn't, that it'd be okay to just not do it anymore until the court weighs in otherwise?
Yes.
Thank you. That's all.
Oh, come on.
Mr. Davis, this is a court proceeding, and I have allowed you to appear through Mr. Martinez's phone. Please do not interrupt my court proceeding.
I'm sorry about that, ma'am.
Your next witness, Ms. Gongora?
I have no further witnesses today, Judge.
Mr. Howell?
No witnesses, Your Honor.
Mr. Martinez?
Your Honor, I'll call Eugene Davis. Mr. Davis, did you know anything about the family therapy between the children and Dr. Shinder and you?
No, sir. One time he had one, I think a month and a half ago, that was for a visit. He's never had a family therapy for me. I've never been informed of that. I talked to Dr. Shinder every Wednesday, and y'all can call him next.
Mr. Martinez,
I can't. Family therapy, and I know what papers she talking about that. I read that in my papers.
Hold on, Mr. Davis. Hold on. Let me just ask the question. You just answer the questions, okay? Are you going to Dr. Shinder every Wednesday?
Yes, sir.
Okay. And you did go the last Wednesday. Would that be correct?
Yes, sir.
So you were not aware, and it's just a yes or no answer. You were not aware of a family therapy that was supposed to be taking place between your children and you?
Not a one or two.
Now, as far as, have you allowed CPS to come in and check out your house?
I had Ms. Hightower at first. Of course, this new caseworker wouldn't know. She have never asked me to do that.
And again, Mr. Davis, I just answered my question. It's a yes or no answer. And
Mr. Martinez, he's mumbling and going from his phone to your phone through Zoom. I'm catching about every third or fourth word.
Yes, Your Honor. Again, Mr. Davis, will you allow, it's a yes or no answer, will you allow CPS to look into your house?
Anytime you want, sir.
Okay. And as far as visits, have you had visits with Eugene where y'all played basketball before?
Yes, I did. Dr. Thunder arranged it.
And did you think that went well, that he had something, I guess, that he looked forward to?
I know it went better. He don't like to be closed in the building. Yes, it went well.
All right. I passed the witness.
Ms. Gongora?
I don't have any questions, Judge.
Mr. Howell?
No questions.
Mr. Levy?
Thanks, Judge. Just briefly, Mr. Davis, Dr. Shinder has indicated that, again, this is just what I've read, that you don't take responsibility for things that have to do with the CPS case and are kind of blaming your situation on others. Is that true or not true?
No, sir. The only thing I did take responsibility, I took responsibility for allowing Miss Jennings back in our lives again. That's the reason why I'm back in this situation. I took responsibility.
All right. And so do you understand why CPS is involved again with the children?
I completely understand, sir. That's why I'm doing what I got to do to try to get this stuff right.
All right. That's all. Thank you.
Anything further, Mr. Martinez?
No, Your Honor.
All right. And I think what I heard is that Dr. Shinder has set up family therapy twice. Mr. Davis said he was unaware of either of the times it had been set up for him.
Judge, what I recall from this case is at the last review hearing, they were trying to set up visitation. Dr. Shinder made an attempt to set up family therapy, and they said that the child was not ready. And that's the last I had heard of it. I never heard that they were starting it back up again. And then now I'm hearing that they're starting it up again. So I mean, I guess that was news to me, really.
All right. Well, the one thing that seems odd to me is if it had been set up once and Mr. Davis is going weekly to Dr. Shinder and he missed a family therapy, how we would miss the second one. So we'll give one more go of the family therapy. But once it's set up, Mr. Davis shall, at least 45 minutes before the therapy session is to start, he will confirm by text that he is going to the family therapy session. If he does not do that, how far do the children live from Dr. Shinder's office?
I live about 10 to 15 minutes.
Okay. So 45 minutes before the session is scheduled to start, he shall text Ms. Scythe. Is it the caseworker or is it the caregiver that gets the children to Dr. Shinder's office?
I believe it's the caregiver.
All right. Well, then Mr. Davis shall, in a group text that includes both the caregiver and Ms. Scythe, confirm, this is Mr. Davis. I am on my way to family therapy. I will be there. And if that text message is not sent to the caregiver and Ms. Scythe, then I don't want that caregiver to pack the children up and get them to family therapy if dad's not going to show up. So that's just a good way to make sure everyone is on board. Everyone's going to make the visit. Also, way back the last hearing, based on the evidence, I ordered that Eugene had the right to not visit with Dad. I'm continuing that as far as the visits go, but one thing that can be discussed is there an alternate place that a visit possibly could happen? So that if he'd like to, if that, of course, it's 110 degrees now, but if that's an option, then I want the child to be able to know that's an option. All right. Otherwise, the court has reviewed the progress of the parents on the family service plan. I will continue the department as the temporary managing conservator. I'm ordering that the father will complete a budget and provide that budget to Ms. Scythe, who also then will provide it to Mr. Levy by August 1st, 2023. The court finds that the department has made reasonable efforts to reunify and also to make and finalize an alternate plan. The court approves of the department's plan at this time. The court finds that the mother is not making progress on her family service plan, that the father is making some progress on his plan. Sir, the law requires that I admonish all parents, if you are unable or unwilling to provide a safe environment for your children, your parental rights could be subject to on the court's docket for a final hearing. The department is present through Ms. Gongora. Kevin is the child's attorney and guardian ad litem. John McLeod had previously been appointed to attempt to locate and identify and locate the unknown father. He has filed his summary of efforts and has previously been discharged. Mr. Howell is present for the mother, Amanda Cordero. All right. So neither the mother is here nor the unknown father. You may call your first witness.
The department calls Yolanda Gomez. All right. Ms. Gomez, can you remind the court how Fernando came into the department's care?
Fernando came into care because his mother and him have tested positive at time of birth, and he was removed during birth.
And what exactly did he and the mother test positive for?
Amphetamines.
And did the mother also test positive for methamphetamines at the time of his birth?
Yes.
Shortly after removal, the child was placed with Miss Martin. Is that correct? Or with the Martins?
That's correct.
Has he remained in that placement throughout the case?
Yes, he has.
Have the Martins made a commitment to this child?
Yes, they have.
At the beginning of this case, they were considered to be a relative placement. Is that right?
That's correct.
That changed halfway through. Is that also accurate?
Yes.
And in fact, even after finding out that the original alleged father was not the biological father of Fernando, the Martins still chose to keep Fernando in their care and wanted to make that commitment to him.
Yes.
Okay. And is the department's plan is that to support the Martins moving forward with adoption should Fernando be available for adoption?
Yes, that's the plan.
Now, in this case, the department prepared a family plan of service for the mother. Is that correct?
That's correct.
What were those services?
She was supposed to have a safe and stable home, maintaining employment, complete protective parenting, complete a psychological drug test according to the color code, and I believe get her medications checked with her PCP because of some conditions she stated she had, like lupus, I believe was one of them.
Your Honor, I'd ask the court to take judicial notice of the family plan of service for Ms. Cordero that was filed on October 18th of 2022, as well as the status order on 11/1/22 that made that family plan in order of this court.
The court will.
And Ms. Gomez, you said that there were many services that were listed on Ms. Cordero's family plan of service, correct?
Correct.
Did Ms. Cordero ever complete protective parenting?
No.
Did she ever comply with drug testing in this case?
She drug tested twice throughout the whole case.
And what were the results of those drug tests?
Her first drug test on October was positive for amphetamines and methamphetamines. Then she drug tested in March and she was negative.
Did she ever complete a psychological assessment?
She did not.
Did she ever provide proof of employment to the department?
She did not.
And has she been able to demonstrate or show the department that she's able to maintain a safe and stable home?
No, she has not.
And so really, Ms. Cordero has not complied with any of the services on her family plan other than the 2 drug tests that she completed throughout the entirety of this case.
That's correct.
Now, in this court, parents are not permitted to visit their child unless they are drug testing consistently. Is that correct?
That's correct.
So being that Ms. Cordero only tested twice, am I correct that she only visited her child twice?
That's correct.
And how long were those visits?
They were a few hours. They were supervised by Ms. Martin. I believe maybe 2 to 3 hours. I'm not exactly sure.
And how old is Fernando at this point?
He is 10 months.
So, Ms. Gomez, is it accurate that in Fernando's entire 10 months of life that he's had maybe 6 hours of interaction with his mother?
Yes.
Based on the mother's lack of progress on her family plan of service, her lack of visiting her child throughout the life of this case, and based on the circumstances that gave rise to removal in the first place, is the department seeking termination of her parental rights today?
Yes.
Why does the department believe that that would be in Fernando's best interest?
Ms. Cordero has not shown any permanency towards Fernando. She has not made any changes. She's not able to provide a safe and stable home for him. She has not been a part of his life really at all. He's at the best placement he can be, where he's provided with love, all the care he needs, and all his needs are being met.
And Ms. Gomez, is it correct that the department has made continuous efforts throughout this case for Ms. Cordero to be involved?
Yes.
And has she refused?
She says she will do those services and visit and all of that, but she never follows through on what she says when she does speak to me.
And that's evident by the lack of progress on any of her services, correct?
Correct.
Let's move to the unknown father in this case. Ms. Gomez, there was a father that was named when this case began. Is that correct?
That's correct.
And sometime during the life of this case, he was excluded as the father due to genetic testing.
Correct.
And at that point, the department amended their petitions to include an unknown father in this case.
Correct.
And it's your understanding that an attorney was appointed to try and locate that unknown father. Is that right?
That's correct.
Is it also correct that the department requested a search from the paternity registry to see if any other man
the court will take judicial notice that the paternity registry search and CCJ are on file and that there were no hits, and that occurred before the court appointed Mr. McLeod, who did a diligent effort or diligent search and has been discharged after his search for the identity of the father.
Thank you, Your Honor. Is the department, Ms. Gomez, asking that the unknown father's rights be terminated as well?
Yes.
And do we believe that that would be in Fernando's best interest as well?
Yes.
And I believe you stated, multiple times why you believe that the home that he's in is the most appropriate for him. But just to be clear, he is having all of his needs met in this placement, correct?
Correct.
Both physical and emotional.
Yes.
And the department believes that it's in this child's best interest to move forward to be potentially and hopefully adopted by this family.
Yes.
Is there anything else that I have not asked you that you feel the need to make the court aware of at this time?
Not at this time.
I'll pass the witness.
Mr. Howell?
Yes. When was the last contact you had with Ms. Cordero?
I believe it was in April.
Okay. And when did you say was the last visit she had?
In March.
Okay. And that would have been the reason, I guess, for the last test back in March?
Yes.
And then before March, when was the last visit?
October.
Okay. And you've already testified those are the only 2 drug tests that she gave pursuant to this plan. Is that right?
That's correct.
And the only 2 visits she's had in the life of the case.
That's correct.
Do you know what the current status of her criminal cases are?
I do not.
Okay. That's all I have, Your Honor.
Mr. Keithley?
Your Honor, I I don't believe I have any questions to add to what Ms. Gongora asked on the best interest.
Any further questions of this witness, Ms. Gongora?
No, Your Honor.
Any further witnesses?
I'll call Miss Martin. You are the current caregiver or one of the current caregivers for Fernando. Is that correct?
That's correct.
You've heard Ms. Gomez's testimony about what the department's hopes are for this child moving forward. Is that right?
That's correct.
Do you also believe that your home is the best place for this child?
I do.
Why is that?
Just had him since he was born and just loved him ever since. I can't seem to let him go, so we decided just to keep him.
And is it accurate that your family is wanting to have the opportunity to make a permanent commitment to this child should he be free for adoption in the future?
Absolutely.
Is there anything else that you feel the court should know or anything that you want to say to the court about this child?
No.
I'll pass the witness.
Mr. Howell?
No question, Your Honor.
Mr. Keithley?
I don't really have any questions, Ms. Martin. I just wanted to wish you the best of luck, and you do have long-term plans for this child, right?
Yes, I do.
Okay, and you do plan on you have educational plans that you have for him. Is that correct? For the child? Okay.
Yes.
And all right. And you will be providing a stable home and will be doing your best to meet those needs that he has in the future. Is that correct?
Yes.
And I think you've testified you do wish to adopt if that's an option for you, correct?
I do. We do. Yes.
We all do. Yes. All right. Thank you. I pass the witness.
Thank you. All right. The court finds by clear and convincing evidence that the department has met its burden of proof to terminate the parental rights of the mother, and further finds by clear and convincing evidence that terminating her parental rights to this child is in the child's best interest. I will terminate the parental rights of the mother on the D, E, N, and O ground. The court further finds that any parental rights that the unknown father could have to this child should be terminated for failing to register with the paternity registry. I will terminate the rights of the unknown father for failing to register with the paternity registry. The court finds by clear and convincing evidence that this is in the child's best interest. I will appoint the department the permanent managing conservator of the child. I will approve of the current placement with the Martins. I'll set this for a permanency after final on September 20th, 2023 at 2:00, and a hearing to enter order on 7/25/2023 at 8:45. For a final hearing, if there's nothing further, will be in recess. Present through Ms. Gongora. Casa is the guardian ad litem for the children. Casa is present through Ms. Alvarez and also Ms. Cooper. Charles Levy is the attorney ad litem for the children. Sam Kinslow is present with the father, Furman Cruz. John McLeod is present with the mother, Samantha Ristich. Are y'all ready for a final hearing?
Your Honor, at this time, the department is requesting an extension in this case.
That was our understanding of what the department's position would be, Judge.
I agree. We were informed that the extension would be requested. I think Mr. Levy has agreed also.
About to ask him. Thank you.
I've agreed.
All right. So which one of you would like to state for the record what the extraordinary circumstances are to warrant the granting of an extension?
I will, Your Honor.
All right.
Your Honor, as the court knows, at the last hearing, Ms. Ristich was granted some periods of unsupervised visits. Those have been progressing. She continues to do well on her family plan of service. She did recently get her own apartment. And so the department and the parties believe that with more time, reunification with the mother could be possible in this case, and that an extension of time would allow the parties to continue reviewing her progress and seeing how she's doing so that we could potentially make that happen.
Mr. Levy, you agree?
Yes, Your Honor, I do agree. The mom seems to have got it headed in the right direction. I'm assuming that she understands that Dad doesn't have it headed in the right direction, and that's why she's got her own apartment.
And Costa?
We agree with that. Yes, ma'am.
All right. The court then does find that there are extraordinary circumstances to warrant the granting of an extension in this cause. I will grant the extension that's been requested. Set out a new scheduling order based on the right. Anything further from anyone?
Yeah.
If not, we'll be in recess on the court's docket for a second permanency and final. The department is present through Ms. Gongora. Kevin Keithley is the attorney and guardian ad litem for the child. John McLeod is present, and it seems like Ms. Taylor currently has the mother, Angela Burns, available on her phone. Mr. Howell is present with his client, Mr. Blake. You may call your first witness, Ms. Gongora.
The department calls Jalissa Taylor. Ms. Taylor, you recently acquired this case, is that correct?
Yes, ma'am.
And at the time that you received this case, there had been some concerns to relate to the department regarding how the unsupervised visits were going with the mother. Is that right?
That's correct.
And that's the reason the goal in the report states it's joint managing conservatorship. Is that true?
That's correct.
Have you had time to independently investigate and inquire about some of those allegations?
Yes, ma'am.
And what does the department come to the conclusion about?
I completed a pop-up visit at the mother's home at the time that she had a unsupervised visit with Michael. I did not find any of the concerns to be accurate. There were concerns that there were multiple people in the home, people who are actively using drugs constantly around the youth. When I completed the pop-up visit, only the mother and Michael were there. It was reported that he doesn't eat. Mom constantly gives him takeout food. When I arrived at the pop-up visit, Mom was actually returning home from the grocery store. Do you want me to go through all the concerns one by one?
Yes, please.
Okay, there were also concerns that Mom allows Michael to go swimming without a life jacket, and she does not supervise him while he's in the water. I reviewed safe water with the mother, and she did go and buy a life jacket, but she stated that she does supervise him while he's in the pool.
And I think that's about it. Is that correct, Ms. Taylor?
Those were the main concerns. There was another concern that was reported that she takes him to her NA meetings. I spoke with the mother's sponsor and asked her if that was okay. The sponsor stated that they welcome children to attend meetings, and there's coloring books and things of that nature that the youth can do while they're there if the parent does bring them to the meetings.
And Ms. Taylor, what I'm hearing is that there were concerns brought to the department's attention, and the department was able to, through due diligence on your part, examined those and found that there really weren't any concerns during Mom's periods of unsupervised. Is that correct?
Yes, ma'am. I'd like to add, I also spoke with the neighbors and asked them, is there a lot of people coming to the home? Are there concerns with the people coming to the home? And according to the neighbors, there are not multiple people coming to the home. They did say that there's a male and the mother's sister, but the sister is not acting like she's currently under the influence of any drugs. So at this time, the department does not have any concerns.
And specifically, how many unsupervised visits has Ms. Burns been receiving?
They started in May, and she gets 3 throughout the week, and she gets overnight visits on the weekend.
And so, Ms. Taylor, given the progress that she's made on her services, as well as how well the visits have been going, is the department able to recommend a monitored return at this time?
Yes, ma'am.
And is that what we're asking for the court to order today?
Yes, ma'am.
Now, specifically with Mr. Blake, what are the department's current concerns for him?
There has been a lack of progress in services. When I received the case, I made attempts to reach out to him. I received a long message back. I'm not sure if I have the correct number. I also spoke to Dr. Schinder, and I was advised that he should not have any unsupervised visits at any point.
And have you provided that? Did Dr. Schinder just state that to you in a conversation, or has he written a report specifically regarding any of his concerns with Mr. Blake?
A report was not made. I'm pretty sure that would have been included in the psychological recommendations, but Mr. Blake refused to complete that. But he did tell me that verbally over the phone.
And will you be sure to reach out to Dr. Schinder and have him provide the department with any notes or documents that he has regarding his interactions with Mr. Blake, and then provide that to the attorneys in this case?
Yes, ma'am.
Is there anything else that you feel the court needs to be made aware of at this time?
When I received the case, I sent Mom to complete drug tests. She completed those on the 5th of this month. She completed a hair, a UA for drugs, and a UA for alcohol. All tests were negative. When I spoke with the sponsor, she also mentioned that mom is, she sees mom on a regular basis. Mom is actually in the process of becoming one of the team leads, like she's going to be over the meetings. And the sponsor had no concerns with the youth returning back to her.
Thank you. I'll pass the witness.
Mr. McLeod.
So Ms. Taylor, I guess then the primary plan then is now changing to family reunification?
That's correct.
In our discussions and my discussions with Ms. Gongora as well, I think the department was asking that Ms. Burns and Michael participate in some therapy or counseling, whatever you want to call it. Has that been arranged?
I did submit the authorizations. Michael actually was in individual therapy before, and he stopped going due to issues that were at the caregiver's home. So Michael is going to start back his individual therapy at the mother's home starting tomorrow. She's also going to be doing family therapy for them. And as far as the mother's individual therapy, the service authorization has been submitted with Counseling Network for her to complete those services virtually.
Okay. And we had talked about adding that to her plan in conjunction with hopefully facilitating the success of the monitored return. Are you asking the court to order those services?
We are.
Okay. And has Ms. Burns expressed a willingness to do that to you?
She has.
Okay. Thank you. No other questions.
Mr. Howell?
Just a few questions, Your Honor. I'm reading through your report, and there really are no updates regarding the father's progress on that. Can you kind of tell me why that is?
Because he hasn't done anything.
Okay. So just no updates from the previous report, is that right?
I believe on the, sorry, let me go to his section. On the parenting classes, I included the exact dates that he did participate, and that was not on the previous report.
Okay. Right, you put in the dates attended on that. All right. So all the other sections where it states there are no updates, that just means that Mr. Blake is not engaged in any services.
Right.
Okay. Thank you for that clarification. That's all I have, Judge.
Mr. Keithley?
Ms. Taylor, so you're saying that the monitored return of Michael to his mom is in the best interest of Michael? Is that right?
That's correct.
Okay. All right. I have no further questions, Your Honor.
Anything further of this witness, Ms. Gongora?
No, Your Honor.
Any further witnesses?
Not at this time.
Mr. McLeod?
No witnesses, Judge.
Mr. Howell?
No witnesses, Your Honor.
Mr. Keithley?
I don't have any witnesses, Your Honor.
The court has reviewed the progress of the parents on the family service plan. I will continue the department as the temporary managing conservator. The court does find that at this time that the child shall be placed on a monitor return with the mother. And just so that we're all on the same page, Mr. Blake, you may continue to work your family service plan. And what are Mr. Blake's current visits? Once a week at the department?
He doesn't have visits. He hasn't engaged in any visits.
Okay. They're set up for him weekly by the department, correct?
No, ma'am, he hasn't drug tested.
Okay, that's the other thing is assuming that there's drug testing, there are visits. I'm just trying to make sure. So Mr. Blake, your visits will continue just as they previously had been ordered. I'm going to order that you not go within 100 yards of the mother's home. And I'm going to order that at this time, she will not have any contact between you and the child while the child's on a monitor return. So, you're on mute, sir. 1 second. Go ahead and unmute yourself.
Could you repeat that last statement?
Well, your visits and your time with your child will continue just as they have been since the beginning. You have visits that you're able to go to, supervised by the department, provided that you drug test. But while the child is on a monitored return with mom, until you start making, doing your drug test and trying to have a visit, I'm going to order that you will not go within 100 yards of the mother's home, and that she is ordered to not allow you to have contact with the child outside of your court-ordered visitation. Does that make sense?
Okay, so it's through the department. That means that she can't allow him to visit with me on her own.
Right, because right now the department is still monitoring her, monitoring the child. And I'm really hoping that if you would like to be a father, that you'll start doing a drug test and showing up. And that way the department will be able to see how you're parenting this child, how you're communicating with the child, so that they may be able to make further recommendations. Does that make sense?
Yes, Your Honor. May I speak freely?
Sure.
So I'm not going to say there's a lot of things that are keeping me from being a good father. I believe that I am participating and going through the necessary steps to be a father and a parent. And there are just some things that hinder the progress occasionally. So I'm not sure if I'm explaining things the way I would like to explain them, and I didn't certainly write this down like I probably should have. I'm having some communication issues with the department. And my scheduling, I've seen him 3 times. And yes, I would like it to be more. Fortunately, I can't afford a whole lot right now. I mean, I'm able to afford a home over his head and clothes and food and all that stuff, but the extra driving around, and I mean, I'm active and I keep an active lifestyle. I'm connected with the church, and I'm making sure that I'm staying active as a parent, with healthy decisions, eating, exercising, all that good stuff. And I would just ask if I could keep one caseworker. This is the 3rd caseworker now, and they just change out. Like, I don't know where they go or what happens. Nobody tells me anything. They just text me and say, hey, I'm the new person. And I'm like, well, where did the other person go?
And that's a thing, Mr. Blake. And I understand your frustration. Fortunately, I could court order Jalissa Taylor not to go anywhere, but I'm not sure I can. I understand your concern. One thing that should not change is that if there's issues, reach out to your lawyer.
I have made many attempts to contact my attorney. He has not responded. And also, before the last court hearing was reset, I was told that he was going to call me the day before, and he did not. And so I called and left a message for him to remove himself from the case. So I'm guessing that's why Mr. Howell is here today.
Well, Mr. Howell may be standing in. Who is your attorney?
I believe you assigned Matthew McClinton.
Okay. All right.
And there are some personal things that I have in my life that maybe keep me from having a contact with certain people. So I'm really struggling to satisfy the court so that we can move forward and the case can be dismissed or whatever needs to happen, so that our family can be reunified so that we can have interaction with each other.
All right.
I have no risk of taking drugs. I have drug tests here in the house just in case anybody wants to come over here and act funny.
Mr. Howell can, let me back up. Mr. Blake, if Mr. McClinton's office set an appointment for you, would you be able to make the appointment?
Say it again.
If your lawyer set an appointment for you, would you be able to make the appointment?
I would certainly hope so.
Or a phone call. Mr. Howell, please let Mr. McClinton know that Mr. Blake needs an opportunity to talk about his case. It's bad enough that the department, if he's on his 3rd caseworker and we're 9 months in, not that it's your fault, Ms. Taylor, but we really need to do better for our parents.
Absolutely, Judge.
All right. Granted the monitor return, Mr. Crosby is about to announce the upcoming court dates. But before he does, I think y'all were wanting me to add family therapy for the mother and the child.
I believe that's the department's request, Judge.
As well as individual therapy for mom.
Well, let me ask this question. Something that Mr. Blake said. Is this a couple that they are hoping will co-parent?
The mother told me she doesn't have a lot of communication with Mr. Blake. The family therapy is for mom and son.
Right. I'm just wondering at some point, if dad needs to be added into the mix, please don't not consider that if that's something that you parties decide would benefit this child.
Well, Judge, I know that part of any parent participating in therapy would require them to do a psychological, and Mr. Blake has refused to complete that psychological with Dr. Schinder.
So the law requires that I admonish all parents, if you are unable or unwilling to provide a safe environment for your child, your parental rights could be subject to restriction or termination. Our dismissal date in this case is January 7th, 2024. No, it's not. Mr. Crosby announced the upcoming court dates based on the monitored return, please.
The new dismissal date is January 7th, 2024. The next permanency hearing will be November 7th, 2023. And the final hearing will be December 12th, 2023.
For an initial permanency, the department is present through Ms. Gongora. Kevin Keithley is the children's attorney and guardian ad litem. Mr. Howell is present with the mother, Nora Robles. The father, Rogelio Moreno Jr., is incarcerated. He's been served, correct?
That is correct, Your Honor.
All right, you may call your first witness.
The department calls Terica Taylor. Ms. Taylor, has anything of significance happened since the filing of your court report?
Yes, ma'am, it has.
Can you please detail that to the court?
Yes, ma'am. I spoke to Dr. Schinder this past Monday, who reported that he was not in agreement. His recommendation was not family unification for Miss Annalie, would recommend her remaining with her sister due to the pending charges Miss Nora is facing, the extensive history, and their relationship due to the visitation has been stopped, and Annalise not wanting to return home to her mother, and behaviors doing much better with the sister. He would not want her to reunify with her mother. So the goal has changed to relative conservatorship. Sorry.
No, and that's what I was going to say. So it sounds like, Ms. Taylor, that the goal is changing just specifically for Annalise to relative conservatorship. Is that correct?
That's correct.
And you mentioned that this is in part due to Dr. Schinder's recommendation, but also it sounds like there had been some issues that I believe are also in the report about Annalise not wanting to visit with her mother. Is that correct?
That is correct.
Okay. That is the complete opposite for her brother Amadeo. Is that right?
Yes, ma'am.
Okay. And in fact, I believe the department has made mention, and it could also be in the report, but he is actually, craving that visit, those visits and that time to spend with his mother.
That's correct.
Okay. And so the goal for him still remains family reunification.
Yes, ma'am.
And the mother has completed or engaged in all of her services at this point in the case. Is that right?
Yes, ma'am.
What are the lingering concerns for the department as it relates to Ms. Robles?
As I stated before, she has pending charges for injury to a child. And she just still needs to engage in therapy to address. She just was notified of Annalise's current placement, which Dr. Schinder stated that she took acceptance very well. But I know it had been not reported to her previously because she did not want Annalise to engage with that side of the family. My internet.
Is it also correct, Ms. Taylor, that the department has some concerns that, Ms. Robles has engaged in services in the past, and the department is worried about whether or not she is actually able to articulate anything that she has learned, as specifically regarding protective parenting in this case?
Yes, ma'am. I was going to continue. My internet seems unstable, so I'm sorry. But yes, ma'am, I also spoke with Miss Nora about that today. She stated that she does understand and she did complete a nurturing and parenting class. However, it was via Zoom. And she would she benefits more from in person. So she is wanting to continue to engage. However, it was just concerning due to the extensive history. She has completed protective parenting a few times, and she still told me she had a hard time remembering what she had learned from her classes, despite she did receive her certificate on March the 16th.
Okay.
That is not true.
Objection, Judge.
This is a court hearing. You may not interrupt the lawyer's questions and the witness's answers, ma'am. Your lawyer may call you as a witness, but please don't interrupt the court proceeding.
May I proceed, Judge?
Right.
All right. So, Ms. Taylor, it sounds like some of those concerns, not just the pending criminal case and that are the underlying basis for removal of these children, but also just her the no change behaviors or wanting to see whether or not she can actually apply what she's learned to her parenting. Is that correct?
Yes, ma'am, that's correct.
Okay. For the father in this case, he is still currently incarcerated.
Yes, ma'am.
Have you been in touch with him or his facility to see if there are any services that he is able to do while he is incarcerated?
I did send a letter at the beginning of the month identifying me as the new worker. Since I did get assigned this case, I have not received a letter back. If I don't receive a letter back, I will contact the facility and set up a legal call. I have done that before.
All right. And so you're going to continue to try and make your own efforts apart from how the previous worker was making efforts. Is that correct?
Yes, ma'am.
All right. Anything else that you feel the need to add or let the court know at this time?
No, ma'am.
I'll pass the witness.
Thank you, Your Honor. I want to make sure I understand what you testified to about Dr. Schinder calling you regarding changing the goal regarding Annalise. That was via a phone call. Is that correct?
Yes, sir.
And was he going to amend his report or put anything in writing regarding those recommendations why Ms. Robles should not be reunited with Annalise?
Yes, sir. He even stated that he would testify to the courts if need be.
Okay, so he is going to put that in writing, correct?
Yes, sir.
All right, and you'll supplement that report to all the attorneys in the case. Is that correct?
Yes, sir.
All right. I want to be sure I understand as well. You testified that Annalise does not want to visit with Ms. Robles. Is that correct?
Yes, sir.
I mean, this child's 11 years old, correct?
I believe she's 12.
How much importance is the department putting on 11-year or 12-year-old child saying, I don't want to visit with my mom right now? Are you let her drive in this ship about being reunited with her mother?
No, sir. She's not driving the ship, but her voice is being heard. She's afraid of her mother. I met with Annalise by myself alone as the new worker. And the thing she reported is that she was afraid to be with her mother. I asked her if she would like visits to be supervised at the department. She declined. Prior to me receiving the case, she had already stopped visits with her mom. So I did reassure her that protection would be available at the office if she wanted visits, and she's just not in agreement with it. At that time, I did reach out to Dr. Schinder to obtain his thoughts, and that's when he gave me a phone call back with his recommendation.
How does the department balance the right to Ms. Robles to visit with her daughter?
Her visits are still available. However, if Annalise does not come to the visit, then I can't force her to come. But the visits are offered every week, but she has declined.
Okay. So is that the department's policy now? If a child doesn't want to go visit with her mother, y'all just don't make the child do that anymore?
Right. Correct.
Okay.
She has expressed her safety. She doesn't feel safe.
So, I mean, these pending charges you're referring to, those stem from Ms. Robles disciplining Annalise with a belt. Isn't that correct?
That is correct.
Okay. And that's the only indication that we have why Annalise would be afraid of Ms. Robles. Isn't that true?
I'm not sure why she's afraid. It was my first time meeting with her. She did not go in depth, but I can assume that's why she left marks and blood on her daughter.
You're not aware of any other reason besides the spanking with a belt.
In this case, sure. But she did have previous history where she has abused Annalise. This wouldn't be the first incident.
Okay. Aside from that, you're not aware of any other incidences.
Correct.
Why Annalise would be afraid. Okay. Has the department tried to set up any kind of counseling or therapy, maybe in a joint session between Annalise and Ms. Robles to go through those issues?
Sorry. Annalise just now starting therapy herself, but I did discuss that with Dr. Schinder. He stated due to the history, he didn't know how beneficial that would be at this time, but it was offered.
discussion with Dr. Schender for not only Annalise, but also Amadeo.
Okay. And so, looking through your report, it's about as glowing a report from progress from a parent that I've read recently. Wouldn't you agree with that?
I'm not sure what you've read.
I mean, Ms. Robles has completed all the services that the department has asked. You agree with that?
Oh, yes. She is engaged in the services.
Okay. Everything the department's asked, correct?
Correct.
All right. Now, regarding Amadeo, where are we about moving that situation forward, possibly with a monitored return? What's the position of the department regarding that?
I also talked to Mr. Keithley as well about, and Ms. Robles about, she's currently visiting the child twice a week, supervised by the caregiver. We discussed going to unsupervised visits. It was not agreed upon. A monitor return, I believe that the pending charges is a barrier. We're not sure what criminal charge she will get due to the pending charges. So Amadeo is ready to go home. He does express interest of going home. However, just us not knowing where she stands with that criminal charge would be the only barrier I could think of. I know the caregiver has requested additional help with Amadeo, with having mom visit a little bit more. She also has 3 other children in the home. Mom has asked for Brenda to be also a support. Instead of utilizing the supports who are working. Yes, Judge, I saw your finger.
Take a brief break. I'm going to visit with the lawyers in a breakout room and we'll be right back. I can't remember who was asking the questions when we took a break. It was Mr.
I'll ask some questions of Ms. Taylor, and I'll go ahead and rest, Your Honor. We don't have any other questions.
Mr. Keithley.
Ms. Taylor, with regard to Amadeo, is the main barrier to him going back with mom now just not knowing if mom is going to be doing time or doing probation or something else, some other sanction similar to probation?
Yes, sir.
Okay, so that really is the only barrier right now?
Yes.
Okay. Thank you. I passed the witness.
Anything further, Ms. Gongora?
I don't have anything further, Judge. I think that in our bench conference, I was able to articulate that the concerns regarding Annalise visiting was not just due to, it was very specifically due to what gave rise to the children being removed from this case. And it wasn't just simply the fact that there were pending criminal charges because of it.
And we're only 6 months in. And so we have mom and child who have a little bit of work to do. And then hopefully we're going to get to the point where we can do some family therapy with mom and Annalise. But I don't think we're there yet. Anything further, Mr. Howell?
No, Your Honor.
Mr. Keithley.
Your Honor, if I can just call Ms. Robles for one question. I know you're pressed for time, but
you're fine.
Okay.
Ms. Robles, if you'll go ahead and unmute yourself. And
all right, Ms. Robles, I'm Kevin Keithley, the attorney for the kids. I just have a question about your criminal case. And the only answer I'm looking for is do you have an offer? Do you know what is offered?
No, sir. Per my attorney, Abel Reyna, the last time I talked to him, he said it can take up to a year or two before I even hear whether it can be dismissed. It could be they can say here's a plea bargain. At this point, nothing's been said. Nothing's been. I do have court dates, but they're just arraignment court dates, so it's not an actual court date.
Okay. All right. Thank you. I have no further questions, Your Honor.
Ms. Gongora, any questions of Ms. Robles?
Not at this time, Judge.
Mr. Howell?
No questions, Your Honor.
All right. Mr. Keithley, what is your recommendation with regard to mom's visits or the placement of the children at this time?
Well, the placement for Annalise is really good. She is happy there and likes that placement. With regard to Amadeo, Judge, he wants to go back with mom. And I think the testimony is that the only barrier is the lack of knowledge of what mom's looking at on that charge. I would ask, and I advise my client that just because I ask, it doesn't mean it's going to happen. But I would ask that the court consider a monitored return of Amadeo to the mom. That was my plan, and that's what I'm asking for. I'd hate for that to happen and then her look at an offer of time or something like that. But
the next setting, what is the date and what is the next setting for? I guess the DA's office and the criminal district courts are playing catch up from 2.5 years of COVID.
Oh yeah.
So if we're going to delay and we're going to delay and we're going to delay, and it could be 2 years, what are we going to do? And then in the meantime, we have a child that's not been reunified with the parent on the big what if.
Right.
The real question is, Ms. Robles, if this child is returned to you and then you find yourself in a position of taking a plea for time, will you be able to have a backup for who will care for your child if you're unable?
Yes, ma'am. I have a large support for family and community. And also I have a 17-year-old daughter that will be 18 next month on the 23rd. So yes, I do.
And who is the person that Dr. Schindler was saying should be the caregiver for Annalise?
Are you asking me, Your Honor?
Yes.
Well, we did.
Is it Annalise's sister or your sister?
It's Annalise's sister.
Okay, so you have an adult daughter?
Yes, ma'am.
Would that adult daughter potentially be able to take not only Annalise, but also Amadeo in the event that you had to turn yourself in?
Yes, ma'am.
And would those be people that if the child were placed on a monitored return with you, that he would have good relationships with these folks, that it wouldn't be like a whole new placement with people he didn't know?
That's correct.
All right. Ms. Gongora, I'll give you the last word.
Judge, I think the department has stated throughout their testimony what their current concerns for Ms. Robles are, specifically, yes, the uncertainty of the criminal case, but also just concerns that she has worked her services before and she has not been able to articulate any change behaviors or anything that she can apply to her parenting as of yet. But the department is working with Ms. Robles to start increasing that visitation so that they can give her the opportunity to demonstrate that she is able to be a safe and appropriate parent. And the department just is not at that point as we sit here today, but they could be in the very near future.
Thank you. The court has reviewed the progress of the parents on the family service plan. I will continue the department as the temporary managing conservator. I will order that Amadeo go on a monitor return with the mother, given that there is no safety barrier at this time. The law changed more than 2 years ago. And I did not hear any reason why that this child cannot be safely with the mother. With regard to Annalise, I'm going to continue her current placement. The court finds that the department is making reasonable efforts to reunify and also make and finalize an alternate plan. The court approves of the department's plan. The mother is making progress. The father is not. Ma'am, the law requires that I admonish you if you are unable or unwilling to provide a safe environment for your child, your parent or children, your parental rights are to be subject to restriction or termination.
Ma'am, do you have any updates on the child since the court report was filed?
No, ma'am.
So everything's going well?
Yes, ma'am.
And as it relates to the mother in this case, has she made any progress on her family plan of service since the court report was filed?
No, ma'am.
And she has indicated that she's not going to work her services, correct?
That is correct.
Do you have any other updates as it relates to the mother?
No, ma'am.
Is there anything else you feel the court needs to be made aware of?
No, ma'am.
I'll pass the witness.
Mr. McLeod?
No questions, Judge.
Ms. Harrison?
No questions, Your Honor.
Does the mother want to sign an affidavit of relinquishment?
Not at this time, Judge. I think we're trying to figure out some issues regarding possible placement issues, but things may work towards that direction. But the things are kind of in flux following a PC that we had, I think it was last week.
The current caregivers have the sibling of this child, correct?
Yes, ma'am.
Yes.
All right. Any reason? I'm just thinking I'm not going to hang on to this case for another 6 months.
I will say, Your Honor, I have no issues with placement. That is where this child needs to stay, in my opinion. And so I would be up for either going to mediation, or I think we could also work it out informally, as John and I have already talked some.
Well, I'm wondering if I should set it with 45 days notice and just let's have a final hearing.
I'm good with that.
That's fine, Judge.
I have requested the mother start her camera numerous times, and I don't know if she's here or not, but if she's not going to work services, that's the whole purpose of setting these cases out for a whole year. And there's a policy that we don't just delay permanency for no good reason. I don't know what grounds the department has requested in their pleadings. I don't know if you would prefer to wait for 9 months before we have a final hearing. Maybe we leave it where it currently is set for the next hearing is 11/14. And that would be greater than 9 months. Maybe we just plan on having a final hearing. We'll just plan on starting a final hearing on 11/14, more than likely. Unless there's been a considerable change in the evidence and the circumstances. So, Ms. Apostolo, if you'll go ahead and plan on preparing a report for that 11/14 hearing in case we do just take up a permanency, I'll need a report, but I'm just letting everyone know that that very well may be the final hearing. If mom still isn't going to work services, hasn't worked services, we've got a child in a home that already has the sibling, we got plenty of other stuff to do. Anything further from anyone?
No, Your Honor.
All right. The court has reviewed the progress of the parents on the family service plan. I will continue the department as the temporary managing conservator. The court finds the department has made reasonable efforts to reunify and also to make and finalize an alternate plan. The court approves of the department's plan. The court finds that the mother is not making progress on her family service plan. Ma'am, the law requires that I admonish you that if you are unable or unwilling to provide a safe environment for your child, your parental rights could be subject to restriction or termination. So the next hearing on November 14th will be set at 1 o'clock on the court's docket for a hearing on a petition to modify the prior final orders. They were entered on or about September 22nd, 2020. At that time, it's the court's recollection that the department was the PMC and the parents were all appointed PCs. Is that correct?
That's correct, Your Honor.
All right. And the department's filed a petition to modify, basically to give the current caregiver, Miss Myra Jackson, sole managing conservator and have the department get out.
That's correct, Your Honor.
All right. The department is present today through Ms. West. Amanda Milam is the attorney and guardian ad litem. John McLeod was appointed for the father, Donald Ray Hightower, who is a parent, but who was unable to be served. He has never appeared in this cause. Mr. McLeod is here. Mr. Hightower is not. Spencer Majors is present. Mr. Majors is the father. Antonio Steele is the father of the Steele child. And Ms. Sterling has been served and is in default. Is that correct?
That's correct, Your Honor.
All right. Is everyone ready?
Yes, Your Honor.
You may call your first witness. Is Mr. Majors is the gentleman that's incarcerated? Is that correct, Mr. Crosby?
Yes.
That he requested to be present. Let me ask one question. Mr. Majors, can you hear me?
Yes, ma'am, I can hear you.
All right. My name is Nikki Mundkowski. I'm the judge that's been seeing this case, since about 2019. And it's my understanding you're incarcerated.
Yes, ma'am.
You understand that the department has filed this lawsuit to modify the prior final order in order that the department can be dismissed and get out of these kids' lives.
Yes, ma'am.
And they are asking that the current caregiver, Miss Myra Jackson, be basically the person who has custody, who's taking care of these children. Do you understand that?
Yes, ma'am.
Okay. And are you in favor of that?
Yes, ma'am.
Okay. Ms. West, I'm sure has some questions, but I just wanted to make sure that you understood what was going on today.
Yes, ma'am.
Ms. West, you may proceed.
Judge, may I ask a question before Ms. West begins? I just didn't know. I'm going to have to put some objections as to Mr. Hightower, and I don't know whether you wanted to do that at the beginning or when you get to maybe Mr. Hightower. But just
you can go now.
Okay. Judges, as we previously discussed. I think that unfortunately, the service of citation on Mr. Hightower did not comply with Rule 102.010 of the Family Code in multiple ways, particularly in terms of meeting the requirements of paragraph C or paragraph E. Paragraph E, particularly dealing with the citation by posting provisions. Additionally, even if it were to be found under, to be possible to be served under some other provision in the rules of civil procedure or the family code, the nature of the suit as reflected in the citation does not properly describe why the court's here today. I realize these are technical violations, but they are really the essence of starting any type of lawsuit. So I think I have to make these objections on the record. I think there was some suggestions about possible waivers on this, but without having spoken with Mr. Hightower, I don't think that I'm in a position to be able to to waive any of the rights that he has to proper citation. I will put on the record that I have not been able to locate him either, other than a possible workplace, which I understand from today that the department does not believe that he's working there any longer. But I have to put those objections on the record, and I can't make any waivers on his behalf because I haven't been able to talk with him.
Okay. Response, Ms. West?
Your Honor, Mr. McLeod is referencing language that is included in the citation specifically that it is not clear that a modification is being sought, rather that this is an original suit for termination or adoption, Your Honor. But however, in this case, we're not seeking termination of his parental rights. Rather, we are seeking only a modification. And the only thing we are seeking is a change in the conservatorship, managing conservatorship of these children. We're not asking for Mr. Hightower's rights to be impacted in any way, shape, or form. And so looking at the due process implications of this case, Mr. Hightower was made aware through the publication that was provided of more severe pleadings and are actually what is taking place today.
Actually, I thought that the citation was very clear, that it said you have been sued. There has been a suit filed that affects your parental, that affects the suit affecting the parent-child relationship. Isn't that what it says?
Yes, Your Honor. And
it says for a modification.
Your Honor, yes, it specifies that there is a modification. And then further down, I believe what Mr. McLeod was referencing, it says the nature of this suit is a suit, original petition for termination of parental rights. But it does specify, Your Honor, that this is a suit for modification on the citation.
All right.
It's, if I may, Judge, it's
One second, Ms. Milam.
Judge, just for the record, I have Ms. Jackson on the phone here, and so she is listening here on my cell phone. Judge, I concur that while the face of the order does not state the right statute, I think the affidavit supporting the motion and the facts that the court found for substituted service are sufficient to warrant a citation by publication and by posting under 109 of the Rules of Civil Procedure. I think that what the department did comports with that rule, and like Ms. West said, the due process was served in this case, and so I would ask the court go forward with the hearing today based on that.
So here's my question to you, Mr. McLeod. If the citation said what you wanted it to say, you would have done exactly the same thing to try to locate your client, correct?
I'm sorry. I'm not sure I understand the question.
If the technical issue that you are complaining about in the citation were correct, you would have still been appointed and you would have still done exactly what you have done, trying to locate Mr. Hightower, correct?
Well,
yes,
Judge, I think that
yes or no?
I can't answer. I'm sorry.
You would have tried to find him just the same, correct?
Well, I would have tried to locate him, yes, ma'am. But I also have a duty to look at the citation, and there are multiple things wrong in terms of the citation under the rule that the order was issued under. If you want to go back to the other, I mean, the rules of civil procedure, I mean, but the order for service of citation like I said, that this E is the only one that dealt section E or paragraph E of 102.010 is the only one that deals with posting, and it requires no knowledge of the last name.
Okay. This court rendered the order for citation by posting at the courthouse based on Rule 109, regardless of what the motion asked for. That is that I can make a finding. I know it says 102, but the bottom line is the same exact due process it's the same amount of due process one way or the other. I've taken your objections. You may call your first witness, Ms. West.
The department calls Roy Gallen. And how are you involved in this case?
I'm the primary caseworker in the case.
And Mr. Gallen, am I correct in that these children are currently placed with Miss Jackson?
That is correct.
And they've been placed there for quite some time. Is that correct?
Yes, several years. Okay. That's correct.
And during those several years that the children have been placed with Miss Jackson, has the department had any concerns about the care Miss Jackson's provided the children?
No, the department has not.
And am I correct, sir, that Miss Jackson has been able to meet the children's emotional, physical, medical, educational needs?
Absolutely. Correct.
Does the department have any concerns about Miss Jackson's ability to take care of these children moving forward?
No, the department does not.
And am I correct, sir, the department believes it's in the best interest of these children to remain with Miss Jackson?
That is correct.
So today, sir, is the department asking for Miss Jackson to be named the sole managing conservator of these children?
Yes, that is correct.
And the department believes that's in the best interest of these children, correct?
That is correct.
And as it relates to the parents and their conservatorship rights, am I correct? The department's recommending for each of them to remain a possessory conservator.
That is correct.
And for their possession and access, that was delineated in the final order to remain the same.
That is correct.
And does the department believe that that arrangement with the parents and their conservatorship, possession, and access is in the best interest of these kids?
Yes, we do.
And am I correct, sir, that the only request really the department is making today as it relates to changes with the parents is for them to pay child support and cash medical support to Miss Jackson?
Absolutely, that is correct.
And to help support these children?
Absolutely. That's correct.
And, sir, is the department recommending that the parents pay minimum wage child support?
Yes, that is correct.
Namely, that each father pays $227 of child support and the mother pays $337 of child support?
That is my understanding, yes.
Have you had any contact with the fathers at all during this case?
Only by letter, and Mr. Major has a courtesy worker that sees him at the prison that relates back and refers back to me to his contact with him, keep him updated with everything that's going on with the case.
Have you had any contact with Mr. Hightower?
No, I have not.
And to your knowledge, has Mr. Hightower had any contact with his child?
Not to my knowledge.
And you mentioned Mr. Majors is incarcerated, correct?
So there'll be no child support for Mr. Majors while he's in TDCJ.
Correct. To your knowledge, he's not had any contact with his child either.
Only by letter, correspondence, telephone calls, those kind of things.
Okay. And Mr. Gallant,
I've got an adversary 8 minutes ago in the annex.
Mr. Gallant, the department's asking me to dismiss, correct?
That is correct.
I will pass the witness then.
Any questions, Ms. Milam?
No, Your Honor.
Any questions, Mr. McLeod?
Just one or two, Judge. Mr. Gowan, in your email dated January 26, 2023, you said that you had been given information that Mr. Hightower was working at Cheddar's.
Yes, that information came from Ms. Jackson, and yes.
Did the department take any steps to follow up on that?
Well, when by the restaurant, they had no knowledge of him. And then Ms. Jackson, I think in one of the visits, told me that he had recently got terminated or something to that nature. She found out that due to altercation there, and that was the last I heard of it.
Okay.
Yes.
Thank you. No other questions.
Any further witnesses, Ms. West?
No further witnesses.
Ms. Milam?
No witnesses, Your Honor. I would like to give Ms. Jackson a brief moment to address the court if she wishes.
All right. Ms. Jackson, is there anything you'd like to say at this point? You are the current caregiver.
Yes, ma'am, I would like to say that I have had them since 2019. CPS has never had to come in and say anything to me. All three of these children, If Mr. Hightower walked up to Kanaya at this point in time, she probably wouldn't even know who he was. I don't know what the problem is with that. I've never tried to keep them away from their parents. So it's not that I have done anything to not have them available for them to come and see their children. I've never denied them that right. Their mother spends so much time with them, as much as she possibly can. She supports them in every way that she can. They never have to worry about their hair, their haircuts, and if they need clothes, if I need help with this, that, or the other, their mother has always been there for me. And I've never denied any of the dads to be able to see the children. So I don't know what it is with this with Mr. Hightower, but Mr. Hightower lives right here in Waco, Texas with this child. He has chosen not to be a part of this child's life.
Yes,
I
ma'am.
didn't give him that.
So it sounds like you would agree with Mr. Gowan that these orders are in these children's best interest.
Yes, ma'am, I do. Okay. These children have been well taken care of. And Mr. Gowan is so correct in saying that I have done everything that they've needed.
Yes,
both
ma'am.
physical and emotional.
Well, thank you so much for that. Judge, I don't have any other questions for this witness.
And Ms. Jackson, you're going to miss the department, right? Since they've been in your home for the last 4 years.
Judge, do you want me to tell you the truth or do you want me to sugarcoat?
No,
I'm going to say yes. If I tell you the truth, it's going to be, Judge, I'm going to be so glad to get rid of this.
You're going to have a party, aren't you?
Oh, my goodness, a big one.
Well, I appreciate you taking care of these kids, ma'am, and we are trying to get this wrapped up. Thank you so much.
Thank you, Judge. Thank you so much.
Thank you. All right. The court will grant the relief requested by the department, except that at this time, the court is not going to order child support at this time be paid by Mr. Donald Hightower. I'm not changing anything in this court order that takes away from the rights that he had in the final order.
Yes, ma'am. I think that would alleviate any potential concern.
The court will also likewise not order child support for Mr. Spencer Majors at this time since he's incarcerated. The law changed a little bit ago. You know, Mr. Majors, I hope when you get out, whenever that is, you can help Ms. Jackson out with your child. She can go and request the OAG get child support, but if you can help her out, then that might save everybody some time. I am ordering the mother. Go ahead, sir.
I was going to say, yes, ma'am. That's definitely part of my plan. I just appreciate everything she's done for the kids while getting my life straightened out with this place, and hopefully everybody can move forward from this, and the best interest be the kids, and that's what's all that matters at this point.
I think sometimes having a caregiver just hear a parent say thank you is pretty darn cool. So thank you. I'm ordering the mother and Mr. Steele pay child support and cash medical as requested. I'm setting this for a hearing to enter order on August 1st, 2023 at 8:45. If there's nothing further, we'll be in recess, and I've got to run to the annex for the 3 adversaries.